think critically and carefully about the relationship between student protest on the one hand, which historically has been a constitutive aspect of university life, and academic freedom on the other, which, as you all know, I hope, is a core aspect of university life. So what precisely, or when precisely, does student conduct transcend the borders of professional speech? Sounds like an easy question, but to say it's rather difficult. How do we know when that transition has occurred? And what do we do about it, assuming that what do we do about it in terms of institutional governance? And what do we do about it in terms of mobilizing the criminal justice system? That's a rather abstract question, I know. We want to think about it in the context of a very specific case, a case with which some of you are at least moderately familiar, the so-called Irvine endeavor. Now, to say that this case is controversial is perhaps the only uncontroversial thing I can say about this. So I think I will get an amen with respect to that, and perhaps not with respect to anything else. But it is a case about freedom of speech, and it is a case at the same time about student protest. So we need to think about how these two things come together. And part of the controversy about this case, quite clearly, is that one's invocation of it always involves the elephant in the room. That is to say, the backdrop of this case is a debate about the Palestinian-Israeli conflict. And I'm hoping that we can think about the precise doctrinal questions without having that determine how we think about it, but I wanted to be sure to at least name that as a point of departure. So the controversy centers, of course, on pro-Palestinian protesters intervening in the speech that was delivered by the Israeli Ambassador Michael Oren. So rather than my trying to describe the scene, let's capture it the way that we capture most things these days, via YouTube. So we'll play it, and after which I will introduce the speakers, each of whom are very well situated to help us speak about that stage. Let's see this one.
And that I have great respect for, Ambassador Michael Oren.
Thank you all, thank you. Thank you all, shalom. It is a great delight to be back at UCI. It's UCI. I spoke here about 5-6 years ago to a somewhat smaller gathering. It is a source of frustration that as a person who spent much of his life speaking Hebrew...
Michael Oren! Propagating murder is not an expression of free speech! Shut up!
Having one person do it is fine and not in the system, but we're going to be polite and courteous to our guests. So the Prime Minister shook his head ruefully and said, for some reason that I can't fathom, oh yeah, you're going to have a hard job. And then later I met the Foreign Minister of Israel. Those of you know him. This is beyond embarrassing. I have been a faculty member here for 26 years. I have been a faculty member here for 26 years. This is no way for our undergraduate students to behave. We have the opportunity to hear from a policymaker relevant to one of the most important issues facing this planet, and you are preventing not only yourself from hearing him, but hundreds of other people in this room and hundreds of other people in an overflow room. Shame on you. This is not an example of free speech. Then those of you who are intent on disrupting this event, now that you've made your point, stand up and leave. it's not Jerusalem, but it's also not Tehran. And so, our minister, not known for being queasy, looks at me and says, boy, you're going to have a hard job.
Right, so there you have Exhibit A. What does one make of that particular moment? And so we can ask a series of questions that might get us thinking. One is, I mean, if I were to ask, was that activity disruptive? I'm not asking a doctrinal question. I'm not asking you to answer the constitutional question about whether what the students did is protected or not. I'm asking a question about disruption. Did that interfere with the speaker? I want to ask you to show of hands. But my sense is that many people would say there was some kind of interference. To what extent there might be some disagreement. I'm going to ask a different question. So you're the speaker. I'm standing now before you speaking, and I experienced that pushback. What would my reaction be? Well, of course, I didn't like it. That doesn't answer the first question either. Let's ask a third question. I think all of us, think about this particular episode, although it's a crucial one, all of us could imagine some speaker who is speaking in that context, for whom we would say the students should get up and speak back. There's some speaker, it might not be this one for some of you it is this one, but the point is there's some moment that we can hypothesize where that kind of activity is one that we might say is something students should engage in. A fourth question, how many of you, I think, were surprised that student protest of this sort, that is non-violent in its orientation, on a university campus would result in criminal prosecution? So now we have a comfortable show of hands, is one question that people might want to know. That is to say, quite apart from how you think about it, you might say, well, I wouldn't necessarily have thought that criminal prosecution would follow from that. And the fifth question I want you to think about as we have this conversation is a question about chilling speech. So now that we know that this is indeed activity that can render one vulnerable to criminal prosecution, the question is what we might think that does to student engagement more generally. And this question, by the way, has nothing to do with how you feel about the substantive content of the speech, or it shouldn't. So here's what one person, by the way, who comes at this from the other direction in terms of the speech, had to say about the chilling effect. The person says, and this is an historian, this is in quotes, if a pro-Hamas speaker was coming to campus and Jewish students came to me for advice on how to respond to him, I might well, before this particular moment, have suggested that they do a quote-unquote die-in at his talk, put on paper masks of Israeli killed in suicide bombings, and come to the front of the hall, say their name and dates, that they were killed, and fall to the floor. Perhaps even have themselves carried out to emphasize the point. Until now, I would have assumed that as long as this didn't prohibit him from finishing his talk and was nonviolent, that would not only be acceptable, but also a highly effective and even pedagogical way to go. Yet it would now seem that my advice might well be illegal and lead to my arrest, prosecution, and even revocation of tenure. Now he goes too far. Along with the suspension, but that might just be my own fantasy. Along with the suspension and expulsion and prosecution of the students who staged the protest. That clearly is what we see in this case. So the point about protest and chilling speech has nothing to do with the content per se, but rather the broader dynamic that we should be thinking about. You didn't come here to hear me. I'm the only moderator. You came here to hear these distinguished speakers. Let me introduce them one at a time. Jacqueline Goodman Rubio is not here. In her place is Robert Hickey, who is from the firm Jacqueline Goodman Rubio, where he specializes in criminal law. He has over 30 years, specifically in the context of criminal law, 15 of which I believe is in the context of criminal defense. So he'll give us a very on-the-ground understanding of the case, the facts, and the legal issues that it implicates. Then we'll move on to Ms. Ameena Qazi, who is the Deputy Executive Director and Staff Attorney for the Council on American Islamic Relations, the Greater Los Angeles chapter. She has expertise in First Amendment, religious freedom, equal protection, and due process, and in a way will sort of broaden the frame. That is to say, to link this particular activity to broader questions about dissent and surveillance. And then we'll bring it back to the ground again in a way by inviting Ms. Marya Bangee to speak, who is a 2009 graduate of UCI and who was the vice president of the Muslim Student Association. So let me shut up, sit down, and
Good afternoon, everyone. How many heard about this incident prior to today? How many people saw the YouTube video prior to today? How many people are concerned about their First Amendment rights when it comes to this case? Good to see that. First of all, that's how I got involved in it. As I'll stand here and say that I'm not pro-Palestinian, I'm not pro-Israel, I'm not. This isn't political for me. I'm here for the Constitution of the United States. When I found out about this, I was just livid. There's two places you should be able to express your views, and that's on the courthouse steps and the college campus. So when this incident happened, I got involved because a colleague that I'm involved with was asked me if I'd participate in it. And once I got involved in it, I said gladly I'd love to help out. So that's the first question was how I got involved. Now the facts about the case, again, without taking sides, because I don't want to give the impression I'm leaning either way. But if you had a speaker that was coming to your school that was somebody that really, really repulsed you in his views or her views, I think that you should have the opportunity to stand up at least and state your point of view in that arena. And that's exactly what happened in this case, is that you had some students who heard about Mr. Oren coming to the school. They were concerned about it. They actually went to the campus and professors and said, hey, look, we think this is going to be a problem. They asked for the speaker not to come. The speaker is coming, they said, and you don't really have a whole lot to do about it. So in the meantime, they put their heads together. And by the way, like you, they're all top students. They're all remarkable people. I think they're all going into medical school. You sit down with them for 5 minutes, you're very, very impressed with them. Anyway, so they all put their heads together and said, okay, what can we do here? And their idea was to come up with this type of a protest. And in their correspondence and in their plans, their correspondence said that this is not to be there's no violence, there's no resistance, and it's going to be a peaceful protest. That's exactly what we want when we do these types of protests. So, as we all know, they each prepared a one-sentence statement that they would shout out, and then once they shouted that statement out, then they peacefully walked to the side to the arms of the awaiting police officers. What you don't see on the video is that this went on for a long time. The meeting was, I think, about an hour and a half long. This is edited, so it looks like they're doing it back to back to back, but they're not. It's more spread out. What you don't see here is that Mr. Oren finished his speech. When the 10 of them finished, the whole group got out and then exited the building. We're wondering if there's 10 of them, how do we end up with Irvine 11? We end up with the 11th, who's my client, who was the last individual to be arrested. On his way out, as they were exiting the building, he shouted out, "Whose university?" And the rest of the students shouted out, "Our university." And for some reason, that's illegal conduct in here. So, by all means, he didn't interrupt the speaker. He was just grabbed by the police, who were ready to put handcuffs, I think, on anybody at that point in time. If you watch the video, and I invite you to watch the video in its entirety, you'll see a lot of other people that are a lot more disruptive. And again, not taking sides, but from both sides of the political view. People were making a lot of noise in that room, and only the students were arrested. Any questions about the facts before I move on to that? cover the facts. After that incident was over, they all met outside, all but 11 of them met outside, and they had a further protest out front, and then the school later called them in, and I think there's some discipline that I don't want to get into at this point in time, but worst possible outcome, I've been asked to give you the worst possible outcome. They potentially could go to jail for 6 months to a year, each one of them. In my view, I'm telling all of them that's not going to happen. I can't imagine a judge on this earth that would do that to them under these circumstances. But you never know. You never know how the trial comes out. We don't know what we're going to get. It's always a risk they take when they go to trial. One of the questions I'm being asked to answer is why the DA brought charges, and I could spend an hour talking about that subject. I'm very, very, very suspicious why the DA is bringing charges. I've never seen in my career the government spend probably in excess of $100,000, if not more, probably a couple $100,000 investigating this case. They seated a grand jury. A grand jury did an investigation, summoned and subpoenaed witnesses. They served search warrants on everybody that was there with cameras, search warrants on family members. They harassed family members to find out where they could find these people. They drove from Orange County to Long Beach to pull people in. They went, again, I don't know what motivates them, but it's unbelievable that they went to this extent to prosecute what is just a misdemeanor case. I do have a theory, and this is the first time I've shared it with anybody. I'll share it. Might get myself in trouble by doing so. But the DA, Tony Rackauckas, is Republican. The head of the Republican Party is a guy by the name of Michael Schroeder. Michael Schroeder and Tony Rackauckas are best friends. In fact, Michael Schroeder funded Tony Rackauckas' campaign. So that's a little bit fishy. Tony Rackauckas' chief of staff, second person in charge, is Michael Schroeder's wife. So you've got Tony Rackauckas, who's accountable now, very accountable to this Republican leader. And we believe that some of the contributors are leaning on the Republican Party to say, make an example of the Muslim students. That's my theory. So, but there has to be something more behind the scenes, because in my career, I've never, ever, ever seen so much effort go forward on such a minor case. And you also have to ask yourself, Google, protest, interruptions, speech, those three things, and you're going to see that this happens to President Obama, it happened to President Bush, it happens to every politician out there, it happens to professors, it happens everywhere. And when is the last time you've heard of 11 people getting arrested over something like this? Usually at very, very most, they'll detain them, they'll take them outside, they'll stop the disruption, and that's the end of it. My final note is, that makes it even a little bit more suspicious for me, is that we've had the Jewish community has come forward and signed hundreds and hundreds of petitions, Jewish leaders saying, please stop the prosecution, we don't want this. We have 100 professors plus, including Mr. Chemerinsky, signed a petition, 100 professors at UCI, saying stop the prosecution, we don't need this, it's going to be divisive to our community, it's going to be divisive to our campus, and for some reason they've elected to go forward. So I'm suspicious, I guess, and I can't give you the exact reason, but it's very, very suspicious. Any questions? Thank you.
Two questions really. One, plea bargaining, was that ever on the table? So you all know that most cases get disposed of by a plea bargain. What happened with respect to that discussion? And two, part of Chemerinsky's argument about this case is the sanctions are crazy, but the conduct fell outside of protected speech. How would you react to his argument with respect to the activity being protected speech or not?
Well, I have to admit that most people in this room probably know more about common law than I do right now, because you just probably finished those classes. But, what I've learned over the years, and especially in law school, is I don't think anything's black and white when it comes to law. I think everything's mostly gray. It depends on how good you're at arguing either side. The seminal case in this that's going to govern this case is a case called In Re K. In Re K briefly is a case that happened in Indio, where there were some farm workers who were hoping to get a boycott of grape sales, and a politician came to speak. I think it was a county fair, and he didn't endorse the boycott, so they decided they were going to protest against his speech. And so during that speech, they stood up and clapped for 20 minutes straight and interrupted the speech to the tune of 20 minutes. And sports rule, specifically the statute 403, that it has to be a substantial disruption, and that was not a substantial disruption. So my interpretation, with all due respect to the professor and the dean of the law school down there, is that, and it's great, we're going to argue it until we're blue in the face that that wasn't a substantial disruption. The speaker got to finish his speech, and that this should be allowed. Does that answer that question?
The plea bargaining.
Oh, the plea bargaining is very, very interesting as well. And again, my head was spinning on this one. Again, I've been doing this for a long time, and a misdemeanor case, I don't know how many district attorneys the Orange County DA's office has, but we got a phone call saying, come down to the district attorney's office, they want to talk to us about this case. We went down and sat with Tony Rackauckas himself. I mean, it's unheard of that the DA would sit down with you on a misdemeanor case, and he offered us a settlement. The settlement involved 11 people pleading guilty. So you can imagine, I can't tell my clients, don't do it, don't do it, don't do it, but I sure wanted to. And they elected to not do it. So tomorrow's the arraignment, you'll see it on the news. But the plea bargain that was offered was not acceptable because it did include them admitting guilt, which they weren't willing to do. Or Friday, I'm sorry, yes, I got the date wrong. I'm ready to go. Thank you very much. Yes.
Because my understanding, and I only heard about this on radio and PR, is that they actually were indicted with felonies for conspiracy. It wasn't actually the act of disruption, but it was what are the actual charges? Is it a disruption or is it a conspiracy?
That adds to even more, that's a great point, is typically when they seat the grand jury, it's usually to consider whether there's felony charges warranted in the case. So when they seated the grand jury, we're all thinking, oh no, felonies, conspiracy, because as you know, you can file a felony conspiracy. They seated that grand jury for investigative purposes only, and their purpose for doing that is they had witnesses that would not come forward. So when you're trying to conduct an investigation, police officer knocks on your door and says, tell me what happened, you close the door and say, I'm not interested, thank you. The only way to get around that is to seat a grand jury. The grand jury comes out and serves you with a subpoena, and you're forced by contempt to take the witness stand and testify. So the grand jury wasn't seated to investigate a felony, or to look into felony charges. It was just merely to, in my opinion, coerce those people that did not want to be witnesses to turn into witnesses. So the charges are a misdemeanor conspiracy, and also misdemeanor, it's 403, which basically is, it's a crime to disrupt a meeting, other than a political and religious meeting. And if you want to look at the code, it's kind of an interesting code with the case law behind it. I mean, I guarantee you, you're going to hear a lot about this case. And I hate to say it, I mean, not hate to say it, I'm excited to say it. It probably might even go all the way up to the U.S. Supreme Court, because there's some great, great issues here. It's timely, again, without taking sides of the Palestinians and everything else. That's a hotbed right now. There's so many issues involved here, but I can really, really envision this going all the way up. So. The other thing that's really encouraging, just one more minute, the support's incredible. We're getting emails, lawyers that are flying in from Northern California. I had a lawyer call from back east that wants to help contribute to the financial cost of all this. I think that everybody's starting to realize the impact this could have on primarily youth students and what happens on college campuses. So the support's amazing. So anything else?
I'm wondering, like, the logistics of the trial itself. Are they all being tried in one trial, or are there separate juries, or is it severing the entire thing?
No, I mean, I can imagine, this is just a prediction, but I can't imagine that they would sever this trial. It's all based on similar facts. Out of judicial efficiency, it's going to be tried most likely in the same courtroom. And so I can imagine it will all be one trial in one courtroom.
All right, so we'll hold all of the questions and invite Ms. Qazi to speak.
Hi everyone, good afternoon. So again, my name is Ameena Qazi. I'm the Deputy Executive Director and Staff Attorney for CAIR-Los Angeles. I've been at CAIR-LA for about almost 3 years now, and started helping advocate on the Irvine 11 case essentially the day after it happened, right after the incident. I'm going to primarily focus on context. I feel like a bobblehead right now because I keep shaking my head watching the video all over again and hearing the absurdity of it all. So I do have a leaning, but my leaning is based on my understanding of the law as well and on the context too. Just to I just want to touch on the free speech issue a little bit, and then maybe that's an issue we can go into further. In addition to Andre K. and the heckler's veto situation, which again analyzes, whether or not there was a substantial interruption, because again, Mr. Oren was able to complete his speech. He didn't end up taking questions and answers afterwards. In fact, maybe Marya can go into this as well, at University of California, San Diego, where he spoke the following week, they canceled all Q&A, interestingly, so those people didn't have an opportunity to challenge him then. But another important question here is even though the university has, under the First Amendment, the ability to place reasonable time, place, and manner restrictions on the exercise of free speech within the university grounds, an important question is, it undergoes strict scrutiny, and an important question is whether or not the enforcement of those are reasonable time, place, and manner restrictions is content and viewpoint neutral. What you will find, and again, maybe Marya can go a little bit into this, is the history of the last several years of the Muslim Student Union and its interaction with the university. And its interaction with the university actually shows that there isn't a lot of viewpoints or content neutrality towards Muslim students in terms of their protestations of the Israeli apartheid regime, or what they feel to be the Israeli apartheid regime. Also, in this specific circumstance you just saw, there were the counter-protesters were even more disruptive, or more vehement. Actually, when the professor, the one who kept on saying, "Shame on you, I'm ashamed," and "Don't do this." I mean, he was actually interrupted too. Didn't you hear in the background somebody yelled out something, and then he stopped for a moment, and then he kept going? Well, was that person arrested? Was that person taken out of the room? Again, just because it is dissident speech, just because it is speech challenging the speaker, do we necessarily penalize that speech more? And these are all really important questions that go to the free speech issue. Again, what happens at UCI is not occurring in a vacuum. I mean, for any of us to say, this is, purely a university event, there's no outside forces, no history to this, I mean, we're just being naive. And I think it is an important question when you have had so many, stakeholders, civil rights people, professors come out and say prosecuting is absurd. It is an important question why this precedent is not being set. What is allowing this to occur? What is allowing this anomaly, frankly, in our judicial system to proceed at any level? And the answer to it largely is because we as a society, especially in Southern California, have allowed it to. We have allowed a certain framework and a certain discourse to take place that allows certain people, particularly Muslims, or those who engage in anti-Israel speech, to be largely penalized, to become the bad guy. I'm going to throw out some stats too, starting with across the nation stats about the current climate of Islamophobia and anti-Muslim bias, and then I'll start bringing it down to specifically what's occurring in Orange County. Last year, up until the year ending September 30th, 2009, the Equal Employment Opportunity Commission said that complaints alleging anti-Muslim bias in the workplace numbered a record 803 complaints, up 20% from the previous year and up nearly 60% from 2005. So a 60% increase from 2005 in anti-Muslim workplace discrimination complaints to the EEOC. However, Muslims make up only 2% of the U.S. population, according to the EEOC. Other stats have that as 6%. But bias complaints by Muslims to the EEOC constituted roughly 25% of the total. So 2 to 6% of Muslims in the country, but making up a quarter of complaints to the EEOC. According to Pew and our own research at CAIR, there are approximately, Pew again is the research foundation, there are approximately 35 cases, and this was as of last fall, so there's been several more since then, 35 cases of mosque opposition within the last few years. The DOJ is currently looking into about 11 of them, of those cases of mosque opposition, rezoning issues, building issues. Actually, I would make that 12 because I've been in conversation with somebody from the DOJ Civil Rights Office within the last 2 weeks on a new one. Last year, the Orange County Human Relations Commission issued their annual hate crimes report and said that hate crimes against Muslim Americans in Orange County was up 150% from the prior year. Here are some other numbers. 1 in 5 Americans believe Obama is a Muslim, and over half of those are Republicans. Approximately 38% of Americans have an unfavorable view, according to Pew, of Islam. And according to an ABC poll, that number is actually 48% of Americans who have an unfavorable view towards Muslims. 55% of people say they know little to nothing about Islam, and 58% of people in the study say they actually do not know a Muslim at all. Now, bringing it down to Orange County, I'll give you an example of 2 cases we received in the last week. One came in this morning of a man who was at a shopping center. His mother wears a headscarf. He got back to his car, found a page ripped from the Quran and taped to his car, and also his car keyed all over the place. Last week, we got another case of a school bullying issue of a Muslim in a school who has been bullied for years. The school is doing very little. He was accosted by his bullies after school. They pushed him, and he fell to the ground and broke his wrist. Last week, also, CAIR-LA published a video. A lot of you might have seen it. It went viral on YouTube with over almost 700,000 views, of a hate protest organized by Act for America of Muslims attending a charitable event in Orange County. I would advise you to watch this video. Just horrendous, that's my alarm to stop. Horrendous things spewed at these families attending this fundraiser. Go back home, go back home, go back home. This is the United States. Go rape your wife like you always do. Your prophet is a pig. 5-year-olds, 1-year-olds holding the hands of their moms as they're attending this fundraiser with a crowd of 100 people, spewing this hate at them. And just before this portion of the protest, there was a formal rally, and who spoke at that rally? Several Congress people and elected officials, applauding the acts of this rally and of these hate groups. And for us to think that this is all happenstance is frankly naive. There are groups out there like Stop Islamization of America, Act for America, the Investigative Project, who are organizing, have a concerted effort to demonize Muslims, to demonize our religion, to make it okay for things like what's happening to the Irvine 11 to occur. Again, what they're doing is they're altering the public discourse, the public framework. So all of a sudden, in the name of national security, in the name of protecting our country, in the name of protecting our traditional values, all this becomes okay. The question is, again, what are we going to do about it? When we see cases involving law enforcement, last 2 weeks ago, CAIR, along with the ACLU and the firm of Hadsel, Stormer, Keeney, Richardson, and Rennick, filed a lawsuit, a class action lawsuit against the FBI for unlawful surveillance of the Muslim community, particularly in Orange County, because they sent in a confidential informant to spy on our mosque, gather information on Muslims. These same FBI agents, just to draw a whole big circle for you, these same FBI agents run the Joint Terrorism Task Force all over the country. Specifically, there is an OC Joint Terrorism Task Force, which has OC sheriff's officers on it who also engage in questioning people. And guess what other entity is also on the Joint Terrorism Task Force? The Orange County District Attorney's Office. And when Rachel and several of her colleagues from Jewish Voices for Peace went to deliver their petition of several thousand people on behalf of the Irvine 11, they went and saw on the glass of the receptionist area in the OCDA's office a sign that said jihad, hand-scrawled jihad, pointing this way. And when she inquired about it, go Rachel, she put them to task, they said it was actually a law enforcement training. So when you have the public discourse or certain actors framing the discourse, you have an essentially biased law enforcement training, a biased law enforcement agency arresting and surveilling people. Is it any wonder that this is going on, that we are allowing this essentially to happen? And as Marya will hopefully go over, fortunately there are a lot of things being done to counteract this. If we think that there is a measure of force trying to put this on us, let me reaction to all that is going on. I will leave it there.
Let's take a couple of questions before we go down.
Sure.
If I could ask you to say something more about how you understand the doctrinal test that's been employed in this case, and then I'll ask you about the context. I mean, you very helpfully provided a sense of the context outside of the university, and I'll ask you about that. But with respect to the substantial interruption test, that seems to turn, based on how you articulated, on whether or not a person finishes his
Yeah, if you look at Henri K, there are several factors that the courts will look into. Like whether the amount of time each interruption was, whether the speaker was allowed to finish, the manner in which it was delivered. Was it, people like jumping up? Was it just applause? What was it? According to our understanding of it, this is still clearly protected speech and did not constitute a heckler's veto because Oren was able to finish his speech. He left the stage. In fact, if there was any interrupter at that event, it was probably Professor Rackauckas, who kept getting up and saying, shame on you, shame on you. And actually, if you watch the whole thing, he took several minutes just saying shame on you to the students. He was interested and taken.
This is another one of those. So you're all familiar with these pretty indeterminate tests where it's all these things are relevant to, none of them are dispositive of, and that's precisely the kind of test that you're negotiating in terms of litigation. What's within context and discourse, which you rightly highlight as something that we should be thinking about. So part of the discourse that circulates now in thinking about issues of this sort and the Muslim community in particular is the kind of good Muslim, bad Muslim dichotomy, extreme versus not. So I wonder what role, if any, you think that discourse plays in how people interact in this case, other cases, the statistics that you describe. Does one need to be a good Muslim to generate public sympathy around some of this?
Absolutely, and part of what this case is, or those who are prosecuting this case are writing off of, are certain issues like youth radicalization in the United States, youth radicalizing on campuses. I mean, the fact that these students are being painted as the bad Muslims, the whole issue of these are the type of people we need to watch out for. In fact, Dean Chemerinsky, the 2 days or the next day, wrote an op-ed, and I think it was in the Jewish Journal, about how Jewish students really don't need to worry on campus because they're addressing the issue with the Muslim Student Union. I mean, again, painting this picture of these radical Muslim students who are, taking over the campus and endangering everyone. In fact, just today or yesterday, the university passed a new code of conduct, which actually uses the word terror in it, that it violates the code of conduct for students to terrorize other students. And I'm like, well, this is assault 101. Why do you need to call it terror? Putting somebody in fear of immediate bodily injury or harm. Why do you need this whole other terror context? But they definitely are playing into this good Muslim, bad Muslim, terrorist Muslim, radical Muslim, versus the sort of Muslim who just sits down and doesn't speak up and just goes with the status quo and takes all the abuse that they want.
So just a couple of questions, if you have any.
What is the strongest case on the other side that you guys are fighting against? Like, you mentioned the one that's favorable. What's the one that you're expecting the other side to cite?
You mean specifically in the Irvine?
Yeah, specifically.
Like, what's the case precedent? Is that what you're asking?
Well, yeah, because the one, you guys named the one that's favorable to you. I'm sure there's something.
Yeah, I mean.
There isn't much. That's one of the only cases that's decided for all three.
Yeah, I can't think of any, because again, this case we can clearly distinguish from all the negative precedent for us. So, and then there's.
Give a sense of some of the negative precedent.
Yeah, the negative precedent would be, and you can jump in as well if you know of any in particular. The negative precedent again would be that again, it's not necessarily negative, but yes, interrupting a speech, cases in which the speaker was not able to finish. I think the thing working most against in this case is the concerted appearance or alleged concertedness of it. So so cases that say when it's an organization or a group of people who shut down versus the individuals, I think that's the kind of picture you're building.
Yeah, they revealed their theory yesterday in our meeting, is they believe that this is not a substantial disruption. They think that the clients had attempted to stop the meeting. So they're making a distinction between substantial versus their plan, their conspiracy to entirely stop the meeting, which wasn't the plan at all. They're also relying on Ray K on the language of substantial disruption. They believe it might be on that and is a substantial disruption, and again, they intend to stop the meetings. And it's really, I think, there's only one other case that I know of in that code section that I was able to find, and it's real quickly somebody who was at a school board meeting. They were tired of the trash being on campus, and somebody dumped trash all over the front of it. Courts, of course, said, no, you can't do that. So that's, I think, the only case that really leans their way, but there's no analogy for me.
And I think I think it's the name of the case, but it's essentially the case which originated the concept of heckler's veto, in which, you know, a man was speaking, but then there was somebody in the audience who kind of started heckling, and it caused this whole disruption, so they arrested the person who started, you know, heckling. And I think that's also a case, I forget the name, that the other side is largely relying on in terms of painting this as an unlawful heckler's veto situation. That's it. Great. Thank you guys.
Good afternoon, everyone. So that was kind of heavy, and we've covered a lot of the topics already. So I'm going to kind of go into more of the advocacy aspect of it. I lead the Stand With the Irvine 11 campaign, and it is a coalition made up of alumni, community activists, leaders, trainees, academic faculty members, etc. And as Dick had talked about earlier, we have had an incredible response to this case. So before I go into the advocacy aspect and the response we've gotten and actions that we're currently taking, I want to talk a little bit about my experience at UC Irvine. So I graduated from UC Irvine in 2009, and the incident that you guys saw in the video happened in February of 2010. So that was a year after I graduated. And I was heavily involved with the Muslim Student Union on campus while I was there. And there has, as Ameena alluded to, there has been a history of discrimination and double standard towards the Muslim Student Union for their political activism while at UCI. I'm sure some of you have heard about some of the things that have happened. For example, before I even got to UCI, I believe 2 years before I got to UCI, one of the most famous things that happened was that there were graduation stoles that the Muslim students decided that they wanted to wear on graduation. I'm sure you guys all know about graduation stoles, right? On one side, it said the Shahada, which is the Muslim statement, declaration of faith. We believe in God, in one God, and that Muhammad is his messenger. And on the other side was a prayer asking God to increase us in knowledge. Now, the MSU, the Muslim Student Union, sent out an email to their internal mailing list and asked their students, whoever's graduating, would you like a graduation stole? Please order one if you do. External groups decided that this actually, Shahada stoles, stood for support with Hamas and Hezbollah, and then these students were terrorists, and that they were trying to declare their solidarity with terrorist groups on the day that they graduated. So they created this huge ruckus, and I remember the president at that time was telling us he was in finals week, and he gets a call from Bill O'Reilly being like, I want you on my show tomorrow. And he was like, bro, I can't come on, I got finals. So it was this whole thing, and basically the university had to call in a independent translator to look at the stole and see what it said, and they were able to determine that it was actually just a religious stole. We're okay. Following that, there was a lot of other different situations that happened. Another example would be that while I was there, what we do generally every year is there's a week where there's Palestine Awareness Week, and there's a mock wall, apartheid wall that we set up with like facts and figures and things like that. And this particular week, a friend of mine, his name is Yasser Ahmed, he was driving a truck that holds the apartheid wall. So he was driving, and he noticed that there was a car following him on campus. And so he stopped the truck, and he made a U-turn, he stopped on campus, and he got out of the truck, and he approached the man and said, surveillance, but there had been no proof. And they've been going to different community leaders and police and saying, look, we're being surveilled, we feel like we're being followed all the time, our phones are tapped, our computers are tapped, you know, we hear people when we're, I mean, I can tell you I've had many situations. I woke up once 2 a.m. and there was a man standing across the street from my house just staring up out my window. I was like, who are you? And like, situations like this happening continuously where you're like, how did somebody get my personal emails, you know? So in this situation, he got out of the car, he approached the car, and he's out of the truck, approached the car, and he asked, why are you following me? And the guy ran his car at Yasser, and Yasser dove out of the way, and the car ran off. So at that point, all the students ran after the car and called the UCI police department and said, look, there's a car trying to run over one of the students. And later it turned out to be an FBI agent. So clearly surveillance, right? Another example was this also happened once at UCI, was the OC task force, I believe. An FBI agent was giving a briefing in Orange County at a private gathering, but there was news reporters from OC registrants that are there. And what happened was the news reporters were able to catch something. He said that, hey, we're surveilling the Muslim students at UC Irvine and USC. And so obviously, unless there's some type of basis for this is not legal. So right away the next day, in the news, they started publishing, look, like the FBI is surveilling this Muslim students at UCI and USC. You can imagine the type of intimidation this causes within students, because you're like, okay, we're politically active, but we're still American citizens. I mean, every single person that protested was an American citizen. They, have been living here for many years. They feel, if anything, they actually take their inspiration from, the legacy of the American tradition for protest and for freedom of speech, and from the civil rights movement. So what happened with that was that the FBI accidentally, one of the officials with the FBI had slipped up and said that they were surveilling the Muslim students. So we actually had a town hall in Islamic State of Irvine with the then the head of the FBI, what was his name? Steve Tidwell. And he said, no, we are not surveilling you. We are not surveilling the students at UCI. We are not surveilling the students at USC. And we are not coming into your mosques and surveilling you. At that exact town hall was a man, his name was Craig Montiel, who later turned out to be a informant for the FBI. So you can clearly see the double standard and the type of thing that we were dealing with, right? And that's just like the tip of the iceberg in terms of the type of stuff that we were dealing with. And as I'm sure you all maybe are aware of, is that Orange County is a relatively conservative community county, and there's a lot of ignorance, I guess you would say. I mean, you can look at the Your Belinda video that Ameena pointed to as like an example of kind of sometimes how the atmosphere can be a little difficult for Muslims and for people of color in general. But one thing I will say about UC Irvine specifically is that on campus there's a very different atmosphere from off campus. If you will notice at UC Irvine, we had the Jewish students, the president of Hillel and the Jewish fraternity on campus actually release a statement saying, we feel safe on campus, and it is external organizations that are trying to exploit what is happening on our campus and make it look like it's bigger than it is. And we have had so many, in terms of the school, the atmosphere on the campus, so much support from different school organizations and coalitions working together. So on campus, it's a very different environment. It's not what it's painted out to be, where Muslim students are just crazy radicals. If anything, the year that the Irvine 11 situation happened, the Cross-Cultural Center, which is the coalition of different groups on campus, awarded the MSU a social justice award. So you can kind of see that at UCI, there's a very different perspective on the Muslim Student Union and the Muslim students, and the Irvine 11 specifically. So that's just to kind of give you guys the context. And so our argument as Muslim Student Union, and this is something that we share with the Jewish students on campus, is that we believe that this situation has been exploited and blown out of proportion by off-campus groups who are using this for their own political endgame. Also, I wanted to say Professor Mark Petraka, who you guys saw shouting shame on you in the video, he actually came on, I believe it was NPR, but he came on the radio recently, just a couple weeks ago, and said, I don't believe that the OCDA should prosecute these students. So to show you that in terms of support for the students, we have had over 100 faculty members, including Erwin Cherminsky and the dean of several different departments at UCI, signed a petition and signed an open letter to Tony Rackauckas saying we don't think you should prosecute the Irvine 11. We've had the same type of letter from UC Riverside. The Irvine 11, 7 of the students were from UC Irvine and 3 of them were from UC Riverside. So over 100 professors or faculty members from UC Riverside also signed a petition. I believe 17 professors from UC Davis, specifically from their legal clinic up there, signed a petition saying that they should not be prosecuted, as well as most recently there has been a petition that was released by Jewish studies faculty across the UC system saying that we do not stand behind the persecution of these students. And as part of the coalition, we have a group of academic faculty, I believe it's called the Academic Scholars for Freedom, for freedom. And they are working on a concentrated effort to put pressure on the UC system to say this is not appropriate. Also, the editorial board of the New University, which is a newspaper at UC Irvine, released a editorial saying, do not go after the Irvine 11. This is not appropriate. You are causing tension on our campus, but we have moved on. And they're basically representing the students on campus. So in terms of the coalition, we've had also, in terms of support, I'm just going to go through it really quickly, a couple quick things. Student governments at UCI, UCSD, UC Riverside, UCLA, UC Berkeley passed resolutions condemning academic penalization of the Irvine 11 last year. And then this year, Cal State Long Beach and Cal Poly Pomona joined them just in the past couple weeks with 2 resolutions condemning any type of action against the Irvine 11. Let's see, what else is there? There was a coalition of Orange County leaders, including the Council on American Islamic Relations, various interfaith groups, the Abrahamic Faith Peace Initiative. They've all issued several different letters, open letters to Tony Rackauckas asking him not to prosecute this case. The Jewish Voice of Peace that Rachel is a part of, they have gone out, they have they have collected over 5,000 signatures that they actually hand-delivered to the DA. And one of their points is that there were Jewish students that had actually done this at Brandeis University.
Well, ours was specifically in relation to what happened in New Orleans.
New Orleans, right, where they had, you guys had protested me, they did on here. Yeah, and they had done basically the same exact thing, and they had not received any type of penalization for that. And another interesting thing to notice is that a couple months after the Irvine 11 situation, there were hecklers that did the exact same thing to President Obama while he was speaking on a campus on healthcare reform. And he actually stopped. And what he said was, look, what they did takes courage, and this is part of our American tradition. So exact same situation against the President of the United States on a college campus. And you see the response there versus the response with the Irvine 11. All right, the Asian Law Caucus has showed their support, and many more. I encourage you guys to visit irvine11.com. It's right there. We have all of our statements of support as well as action items on what people can do to help with supporting this campaign. Obviously, the most important thing is raising awareness. What we really want to show the Orange County District Attorney, who is an elected official, is that you are not representing our community. You are not representing Orange County. And in order to do that, we had a town hall last Saturday in Anaheim, and it was a standing room only crowd. We had over 200 people attend, and we had speakers, Rachel Roberts from the Jewish Voice of Peace, Robert Wilfredo from a congregation in Orange County, as well as Hussam Ayloush, the Executive Director of CAIR-Los, Ameena Lekovich, who is Head of Policy and Programming at MPAC, Muslim Public Affairs Council, and Reem Salahi, who was one of the attorneys on the case. Speak to the crowd and talk to them about this case. And what I explained it, how I talked about it afterwards, is like basically like a pep rally. We had this huge, diverse turnout of all these people from all these different backgrounds, and we were all standing with the Irvine 11, figuratively actually, and literally too, because at one point everybody stood up and said, "We're with you," and kind of showing that, look, Orange County District Attorney, you can try to say that, you know, you're doing this on behalf of our community, but this is not something that we accept. This is not something that is representative of our community. sure that we kind of cause a ruckus so people understand why is this so important. And I think that is kind of like my concluding thought in terms of why this is so important. Although I was a student at UC Irvine and I was active politically, the reason why I got involved with this specific case was not necessarily for any political reasons of Israel or Palestine, but because I truly believe that freedom of speech is so important. And as a student at UC Irvine, I fully understood and took advantage of my freedom of speech. And I felt that that was integral to me determining my principles and developing my identity and being strong in who I am. And I think that that's a very, very, very important part to any college student's experience on the college campus is having a free marketplace of ideas and being able to have debate and discussion. Some of it will be uncomfortable, but at the end of the day, being able to come to some type of consensus and understanding and raise awareness and educate. So the chilling effect that this has already had on college campuses, I mean, for example, Reem Salahi, who is the lawyer that's in charge of this case, says that she gets calls now from student groups being like, can we protest outside of an event? Is that okay? Or is that something we'll get arrested for? Muslim students at UC Irvine, I mean, the backlash has been horrible. I mean, their families are telling them, join the Muslim Student Union, keep your head down, don't get involved, don't be active on campus, you know, obviously. And then a lot of different people are just afraid. They're like, well, is this going to hurt our academic careers if we even, like, you know, speak out or, you know, go attend, like, a rally or something like that. So I think the chilling effect is very real within the Muslim students and then also in the greater student population. And I think that always we've had this pushback on freedom of speech between, you know, the government and between college campuses. And the college campuses have always been these bastions of free speech, and we should work to make sure that that remains so.
Right, so you answered one of the questions that I was going to ask you. I'll ask you one more and then open it up. That is the question about chilling students, which you clearly attended to in your remarks. So, you know, you talk about coalitional possibilities, both with respect to students on campus, but also with respect to the broader community. And one thing that seems tricky about that is, are people coming together around the idea that the speech is protected or that the sanction is problematic? It seems like it's both. That is to say, when you mentioned the professor in the clip, for example, I doubt that he's saying the speech is protected, but he might be saying the sanction is inappropriate. That's certainly where Erwin Chemerinsky is. So does that coalition create some difficulty given the different reasons why people might enter it? So I'm entering it not because I think that this is something that students have a right to do. I'm entering it because I think that this is something that prosecutors should not do. Does that create any friction or not really?
Not really, and I think I do agree with you, and I think criminalizing dissent, I think, is a really big thing for most of the people that are involved in the coalition. Is the general idea, like, whether or not people agree or disagree with the against it, at the end of the day, I think our main focus here is criminalizing dissent is something that will set a very negative precedent and will kind of eat away at, you know, the foundation of our principles as America. So I think that's where people are in that sense. And I mean, just like to bring an illusion and to kind of show you guys like one of the reasons why Muslim students hold these types of rights so cherish them. If you look at what happened with the revolution in Tunisia and Egypt, these are, you know, countries where there was no freedom of speech, right? There was like no ability to express yourself, and the people had to go through so much and through such extreme standards, especially if you look at Libya right now and the massacre that Qazi has unleashed on his people as a result of them fighting for their freedom of speech and other rights. I mean, I think that a lot of these students who come from that background, they really cherish those rights because of the fact that they know what it's like when you don't have them.
Thank you very much. Panelists, and then we must call it quits, but we do have time for a few more questions. So let's just take 2 questions if we have them. Yeah. And the back.
This is for the attorneys, and please let me know if you can't answer this with confidentiality. I was part of a collective called Jerusalem's Arizona, and we were also arrested because of this criminalizing of dissent, which seems to be a trend in some countries across the nation. And something we were considering in terms of legal strategy, and I was just wondering if you could talk to us about it, was possibly filing for a Marya motion in terms of the type of discovery. Because based on this technicality of them conspiring to interrupt the speech, which is basically the grounds for their suit. But when you're comparing that to what happened in New Orleans and what happened to Obama and all those situations, I mean, was that ever even considered? I mean, it seems like they're saying that if this had been something sporadic or something along those lines, then it wouldn't have been criminalized. I just feel like it's such a fine technicality, and they just tried so hard to find a way to bring charges against them that, I mean, what do you have to say about that?
So both questions again converge on prosecutorial discretion. So we'll have each of you respond in a minute. Start.
Go. Okay, in regards to the Marya motion, I can't speak to your specific situation, but generally with Marya motions, again, the Marya motion is based off of the Supreme Court, California Supreme Court. It's essentially claiming discriminatory prosecution, and it allows for expanded discovery, and also you can apply also with your motion to dismiss. They're generally we used it recently in another case, but the judge did not allow for the motion to dismiss aspect of it because he said the aside from the discriminatory aspect of it, there was a case there that would move forward. So that is one issue. But absolutely, it's a good tool, and a lot of people unfortunately don't know about it. In regards to the conspiracy, if I'm understanding the charges correctly, they've brought both individual charges for disturbing the peace and also conspiracy charges as well. So not all of it hinges on the conspiracy issue. A lot of it does hinge on their individual disruption. But again, if you're taking their individual disruption, I mean, of 10 seconds, does that really constitute a misdemeanor offense worthy of prosecution? Is that under a minute? Okay.
Do you have last?
I pass.
Yeah, I'll scramble around a little bit. On the conspiracy, they almost had to file a conspiracy because without the conspiracy, you would never find a substantial disruption by each person. Each person's statement was just one sentence. So absent the conspiracy, you wouldn't have a case, in my opinion. As far as the motion, it's rarely granted. It's a great tool to educate the public. It's a great tool to say, be suspect of the government here. We get to air out all the dirty laundry. There's one statement I wanted to mention to you guys that I forgot to mention, that I found absolutely appalling, was Susan Schroeder, who's the chief of staff for Tony Rackauckas, made an analogy to the press that this was just like the KKK interrupting Martin Luther King's speech. And to make a statement like that, to compare these students to the KKK is just appalling. It shows you the discriminatory attitude that they have about this case. So those are the things that we filed that motion that are going to come out. The stuff that we talked about the relationships and all that stuff would come out. And whether the court's going to grant the motion, we don't know, but at least you get to air out the dirty laundry. So as of now, I think that is one of our plans.
And the final point with respect to prosecutorial discretion, some of you might have already taken criminal adjudication, and one of the things we learned in that context with respect to at least federal criminal law is that what the prosecutor does is law, which is to say there are very limited opportunities to contest it under prosecutorial discretion, whether those claims are about misconduct in the context of discrimination or not. And under state law, that's pretty much the state of the doctrine as well. So thank the speakers very much.